Very warm good evening to all. Today's topic is public interest litigation. Now, the name itself is related to public interest. Now, public interest litigation, shortly known as PIL. We all hear High Court में PIL file हुए, in Supreme Court there is a PIL file. Now, the PIL is related to any subject which is of public interest. Now, it can be of about the environment, it can be about the public life, it can be about the road safety, it can be for the school children, it can be for lady or for anybody related to the society life. Now, when we speak about the public life, public interest litigation is not something defined in the law. It is a mechanism developed by the Supreme Court. Now, how this came into picture? Now, what happened many years back? I would say long back. There was a Hussein Ara Khatun's judgment. Hussein Ara Khatun was state of Bihar. Now, in this matter, what happened? 40,000 jail inmates were without any trial. In this case, Hussein Ara Khatun versus state of Bihar. Now, the Supreme Court came to the rescue of these people that this cannot happen. The people cannot be kept behind the bars as jail inmates without any trial. So Hussein Ara Khatun said detention is not the or keeping them behind the bars is not the solution. So whenever you apply for bail also, Hussein Ara Khatun versus state of Bihar do help you. It has been cited thousands of times in all the cases. In one of my, I will give an example. In one of my matter, there was a bail of 50,000 given by the subordinate court. Now I went to the High Court. Justice Oak was sitting. That time I said that the client has been given bail, but the amount is 50,000 which is unable to pay. So suppose somebody is given bail of 50,000 and he is unable to pay that amount or he is unable to bring a surety of that amount. It is as good as refusing him bail. That's why Hussein Ara Khatun was applied that time, and I got a this was divided into 10 five surety. Now, see, Hussein Ara Khatun was the judgment which helped me to get the bail amount divided in because it was difficult that time when I started practice to get a single surety of 50,000. So it was as good as bail was rejected if it is even though it is granted. Another example to understand this, I will give you the example of the Sunil Batra's case. Now, Sunil Batra was also a jail inmate in Tihar jail. He wrote a postcard to the Supreme Court about himself and also one other uh, prisoner is named Premchand. There was a jail warden who has beaten the Premchand on his private part mercilessly. Now, this Sunil Batra wrote letter to the Supreme Court. Now, this letter was converted to the in a PI. Supreme Court said that this was a case which was actually with the attention of the. I will request everybody to not to disturb the meeting in between. Supreme Court converted this postcard into PI. There was some relief. Sunil Batra was in a solitary confinement also. He also said that I also have a right as a prisoner. Prisoner also have a right to under Article 21. So the example of Sunil Batra shows us that even a postcard can be converted into the PL if that later has a substance of something for public good. Also, one more example I will give of Bhavri Devi. Bhavri Devi was a Sathin, a lady who was assisting the NGOs and Rajasthan, where the child marriages were taking place. So she was appointed by Gram Panchayat that level as a Satin. The word was Satin. Here, what happened when she was trying to stop one Bal Vivah, that is child marriage, the people got angry and five people raped her. But no FIR was taken. and nothing happened. Now, what happened when this matter was reported in one small newspaper? Bhavri Devi tried a lot. She report is one small this I would say news item. From that, it continued to reported everywhere, and lot of NGOs came to her help her and filed a writ petition before the Supreme Court. Supreme Court there took this as a PI and came to the rescue of the Bhauri Devi. And these guidelines are known as the Vishaka guidelines, because in this Bhauri Devi's matter, the court said the Bhauri Devi was working for the government. So it is the government's duty to take care of somebody who is working for the government at the state level. So government will be looking after the responsible protection of the wait, somebody is disturbing the meeting. So it was the government's duty to take care of, because she was working for government, and this is how the protection of women at the workplace. This act came later on, but the Vishaka guidelines were active. Now they are of academic interest to everybody. Now there are many such cases. One more example I can give you of PIL, that is of the uh, Par- uh, Pandit Parmanand Katara versus Union of India. Now you know when the accident happens on the road, nobody is bothered to take care of. But in this case, the Supreme Court said that any accident happens, it is the duty of the any hospital, any doctor to first treat that patient, then go for the FIR or the police complaint. First duty is to treat the patient. This was the thing which was brought in the Parman Katara's case versus Union of India. So these all examples give you an idea that PIL is a device, is a mechanism which can be used to help the mankind to the society. So it is one of the important subject tomorrow as a lawyer or as an activist, as any citizen can file the PIL, but lawyer will be required because there is a procedure of the court which requires people. Nowadays there are so many conditions, because sometimes court finds that some people file the PIL only for the purpose of getting publicity or without any proper cause. So there is a some conditions are put now, but PIL is, I would say, still a tool to do something good for the country, for the mankind. So this was for the today in PIL. Next we move to the judgment reading. Can you see the judgment?
No, ma'am.
Wait. Wait. Now,
Yes, it is there.
start from here. This is a very important judgment on the Bhopal case. Please pay attention.
Very good evening, everyone.
Good way.
Early in the morning of December 3, 1984, one of the greatest industrial tragedies that history has recorded got clamped down on the otherwise quiet township of Bhopal, the capital of Madhya Pradesh. The incident was large in magnitude. 2,600 people died instantaneously, and soon a good number of the inhabitants of the town suffered from several ailments. In some cases, the reaction manifested contemporaneously, and in others, the effect was to manifest itself much later. Union Carbide Corporation, a multinational one, has diverse and extensive international operations in countries like India, Canada, West Asia, the Far East, African countries, Latin America, and Europe. It has a sister concern known as Union Carbide India Limited. In the early hours of the 3rd of December 1984, there was a massive escape of lethal gas from the MIC storage tank of the plant into the atmosphere, which led to the calamity. Several suits were filed in the United States of America for damages by the local representatives of the deceased and by many of the affected persons. The Union of India, under the Bhopal Gas Leak Disaster Act of 1985, took upon itself the right to sue for compensation on behalf of the affected parties and filed a suit for realization of compensation. Sorry. The suits were consolidated and Judge Keenan by his order dated 2nd May 1988 dismissed them on the ground of forum non-convenience subject inter alia to the following conditions. First, Union Carbide shall consent to submit to the jurisdiction of the Court of India and shall continue to waive defences based on the statute of limitation and second, Union Carbide shall agree to satisfy any judgment rendered against it in an Indian court and if appealable, upheld by any appellate court in that country, whether such judgment and affirmance comport with the minimal requirement of due process. The United States Court of Appeal for the Second Circuit, by its decision of January 14, 1987, upheld the first condition and in respect of the second one stated in requiring that UCC consent to enforceability of an Indian judgment against it, the district court proceeded at least in part on the erroneous assumption that absent such a requirement, the plaintiffs, if they should succeed in obtaining an Indian judgment against UCC, might not be able to. Any problem, ma'am?
Wait, wait, wait. Now it's going. Can you see?
Yes, ma'am.
Start. Continue.
In requiring that UCC consent to enforceability of an Indian judgment against it. The district court proceeded, at least in part, on the erroneous assumption that, absent such a requirement, the plaintiffs, if they should succeed in obtaining an Indian judgment against UCC, might not be able to enforce it against UCC in the United States. The law, however, is to the contrary under New York law, which governs actions brought in New York to enforce foreign judgments, foreign country judgment that is final, conclusive, and enforceable where rendered must be recognized and will be enforced as conclusive between the parties to the extent that it grants or denies recovery of a sum of money except that it is not deemed to be conclusive if the judgment was rendered under a system which does not provide impartial tribunals or procedures compatible with the requirements of due process of law. The foreign court did not have personal jurisdiction over the defendant. Article 53 Recognition of Foreign Country Money Judgments, although 5304 further provides that under certain specified conditions, a foreign country judgment need not be recognized. None of these conditions would apply to the present cases except for the possibility of failure to provide UCC with sufficient notice of proceedings or the existence of fraud in obtaining the judgment, which do not presently exist but conceivably could occur in the future. The court rejected that plea advanced by UCC of breach of due process by non-observance of proper standards and ultimately stated any denial by the Indian court of due process can be raised by UCC as a defense to the plaintiff. Later attempts to enforce the result in judgment, in judgment against UCC in this country. After Judge Keenan made the order of 12th May 1986, in September of that year, Union of India, in exercise of its power under the Act, filed a suit in the district court at Bhopal. In the plaint, it was stated that death toll up to then was 2,660 and serious injuries had been suffered by several thousand persons and in all more than 5 lakh persons and sought damages up to then. But the extent and nature of the injuries of the artifact thereof suffered by victims of the disaster had not yet been fully ascertained, though survey and scientific and medical studies had already been undertaken. The suit asked for a decree for damages for such amount as may be appropriate under the facts and the law and as may be determined by the court so as to fully, fairly and finally compensate all persons and authorities who had suffered as a result of the disaster and were having claims against the UCC. It also asked for a decree for effective damages on an amount sufficient to deter the defendant and other multinational corporations involved in business activities committing willful and malicious and wanton disregard of the rights and safety of the citizen of India. While the litigations were pending in the US court, an offer of $350 million had been made for settlement of the claim. When the disputes arising out of interim compensation ordered by the District Court of Bhopal came before the High Court, efforts for settlement were continued. When the High Court reduced the quantum of interim compensation from rupees 350 crores to a sum of rupees 250 crores, but UCC and Union of India challenged the decision of the High Court by filing special leave petitions. It is in these cases that the matter was settled by two orders dated 14th and 15th February 1989. On May 4, 1989, the Constitution Bench, which had recorded the settlement, proceeded to set out brief reasons on three aspects. How did this court arrive at the sum of 470 million US dollar for an overall settlement? Why did the court consider the sum of 470 million US dollars as just, equitable and reasonable? Why did the court not pronounce on certain important legal questions of far-reaching importance said to arise in this appeal as to the principle of liability or monolithic, economically entrenched multinational companies operating with inherently dangerous technologies in the developing countries of the third world question, said to be of great contemporary relevance to the democracies of the third world? The court indicated that considerations of excellence and necessities of legal principle were greatly overshadowed by the pressing problems of very survival of a large number of victims. The court also took into account the law's proverbial delays. In paragraph 31 of its order, the Constitution Bench said, as to the remaining question, it has been said that many vital principle of great contemporary relevance to the third world generally and to India in particular touching problems emerging from the pursuit of such dangerous technologies for economic gains by multinational arose in this case. It is said that this is an instance of lost opportunity to this apex court to give the law the new direction of new vital issues emerging from the increasing dimensions of the economic exploitation of developing countries by economic forces of the rich ones. This case also, it is said, concerns the legal limits to be envisaged by the vital interest of the protection of the constitutional right of the citizenry and of the environment on the permissibilities of such ultra hazardous technologies and to prescribe absolute and deterrent standards of liability if harm is caused by such enterprises. The prospect of exploitation of cheap labor and a captive market, it is said, induces multinationals to enter into the developing countries for such economic exploitation, and that this was eminently an appropriate case for a careful assessment of the legal and constitutional safeguards stemming from these vital issues of great contemporary relevance. The Bhopal gas leak matter has been heard in this court by four different constitution benches. The first bench consisted of Pathak Venkataramesh Mishra, or second is Venkatachali and Ojha. Justice, the hearing continued for 24 days. The challenge to the validity of the act was heard by a different bench consisting of Mukherjee, C.J. Singh, Ranganathan, and Ahmadi and Saikia, where the hearing continued for 27 days. The review proceedings wherein challenge was to the where settlement were then taken up for hearing by a constitution bench presided over by Mukherjee with Mishra, CJ with Mishra, Singh, Venkatachali, and Ojha as the other members. This continued for 18 days. It is unfortunate that Mukherjee CJ passed was soon after the judgment had been reserved and that necessitated a rehearing. The matters were reheard at the earliest opportunity and this further hearing took 19 days. Perhaps this litigation is unique from several angles and this feature is an added one to be particularly noted. The validity of the Act has been upheld and three separate but concurring judgments have been delivered. At the final hearing of these matters, long arguments founded upon certain bearing observations of the learned judges constituting the Wires bench in their respective decisions were advanced and some of them have been noticed in the judgment of my learned brother. In the main judgment now being delivered, special attention has been devoted to the conduct of Union of India in sponsoring the settlement in February 1989 and then asking for a review of the decision based upon certain developments. Union of India has rightly indicated is a legal entity and has been given by the Constitution the right to sue and the liability of being sued. Under our jurisprudence, a litigating party is not entitled to withdraw from a settlement by choice. Union of India has not filed a petition for review but has supported the stand of others who have asked for review. The technical limitations of review have not been invoked in this case by the court and all aspects have been permitted to be placed before the court for its consideration. It is interesting to note that there has been no final adjudication in a mass tort action anywhere. The several instances which counsel for the parties placed before us were cases where compensation had been paid by consent or where settlement was reached either directly or through a circuitous process. Such an alternate procedure has been adopted over the years on account of the fact that trial in a case of this type would be protracted and may not yield any social benefit. Assessment of compensation in cases of this type has generally been by a rough and ready process. In fact, every assessment of compensation to some extent is by such process and the concept of just compensation is an attempt to approximate compensation to the loss suffered. We have pointed out in our order of May 4, 1989, that the estimate in the very nature of things cannot share the accuracy of an adjudication. I would humbly add that even an adjudication would only be an attempt at approximation. This court did take into account, while accepting the settlement, the fact that though a substantial period of time had elapsed, the victim were without relief for quite Sometimes the number of claims in court or before the authorities under the Act was not very appreciable. Perhaps an inference was drawn from the figure that the subsequent additions were to be viewed differently. I do not intend to indicate that the claims filed later as frivolous, particularly on account of the fact that there are contentions and some prima facie materials to show that the ill effect of exposure to MIC could manifest late. The nature of injuries suffered to the effect of exposure are not the same or similar. Therefore, from the mere number, no final opinion would be reached about the sufficiency of the quantum. The Act provides for a fund into which of the decretal sum has to be credited. The statute contemplates of a procedure for quantification of individual entitlement of compensation and as and when compensation becomes payable, it is to be made out of the fund. The fact that the Union of India has taken over the right to sue on behalf of all the victims indicate that if there is a shortfall in the fund, perhaps it would be the liability of Union of India to meet the same. Some of the observations of the Wires bench support this view. The genuine claimant thus have no legitimate grievance to make as long as compensation statu- statutorily quantified is available to them because the source from which the compensation comes into the fund is not of significant relevance to the claimant. When this settlement was reached, a group of social activists, the press, and even others claiming to be trustees of society came forward to question it. For some time, what appeared to be a tirade was carried on by the media against the court. Some people claiming to speak on behalf of the social think tank in meetings disparaged the court. Some of the innocent victims were even brought into the court premises to shout slogans at the apex institutions. Some responsible citizens of oblivious of their own role in the matter carried on mudslinging. The main foundations of the
Wait,
challenge was
wait,
twofold.
wait, wait. Shreeyanshi, very well read. This is a Bhopal
Thank
guest
you.
injury case. I would
Madam, you
request.
are in muted, madam. Not
Yes,
audible.
audible now? Thank you.
Yes, ma'am. Ma'am,
Thank you.
what is due process of law?
We will, questions can be taken at the later stage after the lecture. Okay. Now we move to the next session, that is of the legal vocabulary. Judgment reading was done by the Shreeyanshi Shukla. She is from Kashi, Uttar Pradesh. Is it visible now?
Yes, ma'am.
Thank you. The first word is lenient, that is sympathetic. The record shows that it was pleaded before the trial court. The respondent is a lady. And further, that she had three minor sons. These considerations persuaded the trial court to take a lenient view. Lenient means थोड़ा simple. Yeah, I was sympathetic means थोड़ा दया करके उस पे. Mitigating factor, justifying factor. What is the justifying factor? The mitigating factors. The commission should consider mitigating factors while imposing penalty. Penalty देते वक्त commission को थोड़ा देखना चाहिए कि और बाकी चीजें क्या है. What are justifying factors? If somebody is poor, less penalty like that. Bereft, to be deprived of or lacking something. The judgment, according to the learned counsel, is silent and bereft of reasons, which are the heart and soul of the judicial order. Implausible. Not easy to believe. He submitted that the entire premise of rape on false pretext of marriage is implausible. Nuances. Subtle. Often overlooked distinctions in legal language, interpretation, or procedure that significantly affect the case outcome or contract enforceability. Nuances. The originality itself has some nuances to be considered. Credible. Credible to be understood, worthy of belief or competent. Credible है, इसके credibility क्या है? In case of evidence, in case the evidence has a ring of truth to it, see the language, ring of truth to it, is cogent, is true, credible, and trustworthy. It can and certainly should be relied upon. Next is relinquishment. The voluntary intentional, mostly in property matters, surrender of known right, claim interest or property in favor of another person. The plaintiff claimed that a half share in the suit property had been relinquished in favor of himself and his brother. Delinquent. Delinquent is a, उसका मीनिंग दोषी होता है, मीन्स ए जुवेनाइल ऑफेंडर, बट ऑफन अ पर्सन juvenile who has committed an illegal act or a minor crime. Juvenile delinquency in this country, as elsewhere in the world, springs from poverty and unemployment more than it does out of other causes. Hostile. This is the most widely used term in the criminal matters. Witness hostile हो गया. Actions, evidence, or witnesses that are contrary to the interest of a party in a legal action. Complainant के opposite. There is no rule of law that deposition of a hostile witness is to be discarded in toto. Hostile witness ka, I will explain this. Hostile witness give evidence. The part which support the prosecution can be accepted. The meaning is that when you do criminal practice, you will understand. Exonerated means bari karna. A person has been officially cleared of criminal charges. You must have read in Times of India, Mr. So and so is exonerated. A department inquiry was initiated against them for the same charge, but all of them were exonerated. Just a minute. Now move to the next part. Very interesting case laws. I would like to hear all of you what a lawyer can do in his career for a client. Now, what happened in the there was a police constable, his name was Maruti, in the Bombay police. He met with some road accident, so he's mentally somewhere, he was disturbed, and his mental capability to understand was lesser than the normal people. Still, he was kept in the job. He was not removed. He was kept as a constable in Bombay police. Now, as he was poor also, he was unable to do much for his family. Somehow he got a minister's letter to get a vegetable vendor license for his wife. So he used to go to the municipal office mostly every day, and the municipal officer used to just, they were just no, avoiding him somewhat, कल आओ आ जाओ ऐसे करते थे. And what happened, they were also very rude to him. And one day the guard was rude to him. Maybe he gone prepared or what, he burnt himself in front of them. So it was a suicide attempt. So it was a police case, and he was a police constable. The story goes that after this incident also he was kept in job. His job was continued. He was on bail and everything, because the police also knew he needed financial help for his family. Now there was a criminal proceeding against him, and because it was a incident which happened in daylight, there was evidence. He was bound to be convicted for the offense for attempting suicide. So he went to the lawyer and he said, this is an injustice to me. What can be done? If I lose a job, what will happen to my family? Because once he is convicted, he is likely to lose the job. He has to go inside. Then a writ petition was filed before the Bombay High Court saying that a person who commits suicide is actually under a lot of mental stress, and punishing him for committing suicide will be too inhuman. So it takes away somewhere his fundamental right to live. And because if he goes inside, and the right to live also includes right to employment, right to earn the money, all his rights will be taken away. So this writ petition was before Justice P.B. Sawant. Fortunately for him, this matter was understood in this way that because he was mentally disturbed and again putting him behind the jail and coercing with him the criminal trial will be against a more injustice to him. He needs actually a help from the society, from the police department, from all of us. The matter took a different turn. Justice P.B. Sawant quashed his case, that is the FIR filed by the and the criminal charges filed by the police, that is state government, and I could say he was exonerated of the charges. Clear, he was cleared. And because his case was quashed, Maharashtra and Goa, Bombay High Court, that time it was Nagpur, Goa, Aurangabad, and Mumbai. All the pending cases of attempted attempt to commit suicide, all the cases were quashed. मतलब एक ही स्ट्रोक में महाराष्ट्र में all pending cases were closed. So all were released along with Maruti, and Maruti's job continued as a police constable. Now state government went to the Supreme Court in appeal. If see there was another fear. The matter there was taken in a different angle. If this was allowed, right to life does not include right to die. So the matter was reversed. But all the cases, including Maruti's case, which was also quashed, they were kept like that. His job was continued, nothing was done. But matter got reversed, and Section 309, which was struck down from Indian Penal Code, was restored again. But Maruti and all the people who were acquitted of the charges, they were kept like that, and they were not. Their charges were not restored. Their cases were not reopened. So this was a, I would say, miracle for the Maruti one police constable, and because of his lawyer, his counsel, Advocate Shrikant Bhatt argued. There were other lawyers also. He argued so well this matter, and together he somebody who suffers from mental stress cannot be forced again to go defend himself for the criminal charges because he tried to commit suicide. Somebody who ends their life. So see, the matter took a different turn. So whenever a matter comes to this matter teaches us, this case teaches us, whenever matter comes to see from different angle. It may be a arbitration matter, it may be a family court matter, it may be criminal matter. But you have to think from this angle, and this helped Maruti and so many people. And thereafter, Mental Health Act also came in 2017, and in that also this was discussed, and Maruti case may whatever has been said is actually reflects in Mental Health Act of 2017. So this was a story of Maruti. There is a one serial, Bhavar. I think it came in the year maybe 2000 2001, that year. Maruti's case is there in serial in one episode. Vik- Vikram Gokhale's brother, Mohan Gokhale, has played that role very well. It's a 30-minute serial. You will find on the Google. If I get a chance, I will share with you. Do read it, and do read the Judgment. Do watch that serial, and you will understand how beautifully this case was actually handled by the lawyer. So somewhere it gives an inspiration to all of us. This is the way we should do for our own clients. Thank you so much, Chalo, for listening and being a wonderful audience.